Good morning, Dr. Azhar. My name is Lew Wan Yee, and now our group would like to discuss about the Law of the Sea Convention and International Tribunal of Law of the Sea protecting a country's maritime sovereignty. I will now first talk about the policy assigned for both of these laws in protecting a country's maritime sovereignty. Law of the sea is the branch of international law concerned with public order at sea. Much of this law is codified in the United Nations Convention on the Law of the Sea, signed on 10 of December 1982. The convention described as a constitution for the oceans, which represents an attempt to codify international law regarding territorial waters, sea lanes, and ocean resources. In this 1982 Law of the Sea Convention of Settling, it sets forth a comprehensive legal framework for the use and protection of the sea, the seabed, subsoil, and the marine environment, including both natural and cultural resources. Through a wide range of provision, the Law of the Sea Convention establishes clear policy with respect to states' navigational rights, maritime zones, boundaries, economic jurisdiction, while also providing member states a mechanism for international cooperation and dispute resolution. According to the 1982 Convention, each country's sovereign territorial waters extend to a maximum of 12 nautical miles, which is 22 km beyond its coast, but foreign vessels are granted the right of innocent passage through this zone. Passage is innocent as long as a ship refrains from engaging in certain prohibited activities, including weapon testing, spying, smuggling, serious pollution, fishing, or scientific research. Beyond its territorial waters, every coastal country may establish an exclusive economic zone, which also called as EEZ, to extend 200 nautical miles from shore. Foreign vessels and even aircraft are entitled to move freely through or over the zone. With regard to the seabed beyond territorial waters, every coastal country has exclusive rights to the oil, gas, and other resources in the seabed up to 200 nautical miles from shore or to the outer edge of the continental margin, whichever is the further, subject to an overall limit of 250 nautical miles, which is 650 km from the coast of 100 nautical miles beyond the 2,500 meters isobulb. Legally, this area is known as the continental shelf, though it differs considerably from the geographical definition of the continental shelf. The high seas lie beyond the zones described above. The waters and airspace of this sea are open to use by all countries except for those activities prohibited by international law, such as testing the nuclear weapons. On the other hand, the International Tribunal for the Law of the Sea is an independent judicial body established by the United Nations Convention on the Law of the Sea to adjudicate disputes arising out of the interpretation and application of the Convention. The tribunal is composed of 21 independent members elected from among persons enjoying the highest reputation for fairness and integrity and of recognized competence in the field of the law of the sea. The International Tribunal for the Law of the Sea is constituted and shall function in accordance with the provision of this convention and this statute. Besides, the seat of the tribunal shall be in Free and Hanseatic city of Hamburg in the Federal Republic of Germany. The tribunal may also sit and exercise its function elsewhere whenever it considers this desirable. The tribunal has jurisdiction over any dispute concerning the interpretation or application of the convention. The overall matters specifically provided for in any other agreement which confers jurisdiction on the tribunal under Article 21 of Statute of the International Tribunal for the Law of the Sea. The tribunal is open to states parties to the convention, such as the states and international organizations which are parties to the convention. It is also open to entities other than states parties, such as states or intergovernmental organizations which are not parties to the convention, and to state enterprises and private entities which in any case express provided or in any case submitted pursuant to any other agreement conferring jurisdiction on tribunal which is accepted by the parties to the case. Under Article 23, to apply the law, the tribunal shall decide all dispute and application in accordance with Article 293.
On maritime policy issue of LOSC and ITLOS in protecting country maritime sovereignty. Under the Part 2 of the Convention, a state may claim its territorial sea, an area up to 12 nautical miles from its coast. A state territorial sea is subject to the state sovereignty. Beyond the 12 nautical miles and up to 24 nautical miles from its coast, a state may claim a contiguous zone, may exercise the limited control to prevent or punish the violation of its custom, immigration, or sanitary laws and regulation in its territorial or territorial sea. Beyond the territorial sea, Part 4 of the Convention provides that a state may claim an area up to 200 nautical miles from its coast as an exclusive economic zone for the purpose of exploiting and managing living and non-living natural resources, as well as maritime scientific research and the protection of preservation of the maritime environment. The convention gives the United States the largest EEZ of any country in the world. The high sea beyond 200 nautical miles from the said coastline are all open to all users and are not subject to the jurisdiction of the state. Meanwhile, the Convention addresses the limitation of the overlapping territorial sea, exclusive economic zone, and continuous shelf. The provision will apply to maritime boundary delimitation between the countries and do not address boundary delimitation between US. Meanwhile, at the ITLOS, under the Article 292, it provides a limited right of action for a state party when a vessel flying its flag has been detained by the authorities of another state party. These cases usually arise when fishery or naval authorities of the coastal state suspect a fishing vessel is illegally fishing in EEZ. The coastal state then arrests the vessel and is detaining them at the coastal state port. The ITLOS is concerned not protect not only the human rights of the crew but also the property right of the vessel owner, but also the ability of a coastal state to effectively enforce its regulation of the EEZ. Therefore, the Article 292 provides for the prompt release of the vessel and enables the unilateral application of the tribunal in the absence of the agreement between the flag state and the detaining state. That's all for my part. Thank you.
My name is Lew Sum. Now I'm going to share about the advantages and disadvantages of the Law of the Sea of Convention and International Tribunal of Law of the Sea in protecting a country's maritime sovereignty. The 1982 Law of the Sea Convention established a comprehensive legal framework to regulate all ocean space, its uses and resources. It also provides for the protection and preservation of the marine environment, the seabed and subsoil for marine scientific research, and for the development and transfer of marine technology. Through a wide range of provisions, the LOSC established clear guidelines with respect to states' navigational rights, maritime zones and boundaries, and economic jurisdiction, while also providing member states a mechanism for international cooperation and dispute resolution. LOSC is working to ensure the peaceful, cooperative, legally defined uses of the sea and ocean for the individual and common benefits of humankind. LOSC can maximize legal certainty and best secure international recognition of the sovereign rights. The widespread benefits are not limited to the continental shelf and its resources. However, the Law of the Sea Convention provides another tool to effectively resolve conflicts at every level. It provides a common language and therefore a better opportunity to settle disputes with cooperation instead of cannons. The International Tribunal for the Law of the Sea is competent to deal with disputes in which a state is alleged to have wrongly interfered with or otherwise restrained the operation of a vessel when it is in a part of the state or within the territorial sea or exclusive economic zone of the state. In previous judgment, ITLOS has provided clarification of some important areas of the law of the sea concerning the operation and regulation of shipping by flag states and other states. There are many advantages to be gained by states and shipping operators from using ITLOS as the body for the settlement of disputes under agreement. Disadvantages include saving in times and expenses. The disadvantage of Law of the Sea Convention is it endangers the marine ecosystem where the law is in protecting a country's maritime sovereignty. LOSC has not dealt with all ocean uses successfully, such as the protection of the underwater cultural heritage, the management of transboundary fish stock, which was left for more detailed elaboration in the future, and the legal regime of internal waters that was not addressed at all following the tradition of the conventions. The disadvantage of ITLOS is the geographical scope of Article 32 was not specified. According to the Tribunal, although Article 32 is included in Part 2 of the Convention entitled Territorial Sea and Contiguous Zone, some of the provision in this part may be applicable to all maritime areas, as in the case of the definition of warships provided for in LOSC Article 29. Recently, the Mediterranean Sea was the only area where exclusive economic zone had not been established. The development of the first delimitation agreement in Eastern Mediterranean between Cyprus and Egypt on their exclusive economic zones, to the establishment of the Croatian Fisheries Protection and Ecological Zone, the Libyan Fishery Protection Zone, the Slovenian Ecological Protection Zone, as well as the Syrian and Tunisian Exclusive Economic Zone. However, this establishment of exclusive economic zone under various other denominations has caused concern. Although the legal regime of this zone may as well be identical to the regime of an exclusive economic zone or not in contravention to it, the introduction of new denomination is bound to create confusion and uncertainty, especially as to the rights and obligations of other states. Such a potential confusion is entirely avoidable, since there are no legal impediments for any state party that can do so in geographical situation to proclaim an EEZ and to use the term established in the Law of the Sea of Convention. Thank you.
Good day, Dr. Azam. I am Lim Chun Xian, and my student ID is 2002788. And now, I will talk about the suggestion to LOSC and ITLOS for betterment towards sustainability. According to the research, we can note that LOSC set the legal framework for the country's marine environment in terms of ocean, seabed, and so on. It is a good solution to many national disputes and conflicts, and offer the benefits of international cooperation and dispute resolution mechanism to member countries. General Martin Dempsey, the chairman of the Joint Chiefs of Staff in the United States, once said, "The convention provides us with another tool for effective conflict resolution at all levels. It provides a common language and therefore a better opportunity to resolve disputes by cooperation rather than by canon." It is clear that LOSC is very important for a country. Although LOSC has so many benefits for a country, it still has some flaws. For example, he only provides the international cooperation and dispute resolution mechanism to member countries. I think that if LOSC and ITLOS want to be sustainable, they should discontinue the practice of offering benefits only to member countries and offer them to all interested countries instant, so as to gain the support of many countries. Not only that, although LOSC plays a protective role for the ocean, it does not provide protection for the vessel. As I see, LOSC must continue to improve its regulation in order to truly protect the vessel and the ocean, such as adding regulation on how to address the vessel being kidnapped or destroyed by pirates, and so on. ITLOS is a tribunal established under UNCLOS to resolve disputes arising from LOSC and UNCLOS. The ITLOS building is set up in Hamburg, Germany. This is very inconvenient for many countries. Therefore, in order to achieve sustainability, ITLOS could open tribunals in other countries or set up online trials. It would be more convenient and less expensive for people from other countries to travel to. That's all of my presentation. Thank you.